Hey, law friends from 561. Today I'm going to talk to you about a decision called Renaud and the Central Okanagan School District number 23. My name is Mitchell. You'll find me down here on the bottom right where I'll take you through this case. Let's start with the judicial history. So the first instance decision comes from the BC Human Rights Council in 1987. That decision goes for judicial review at the BC Supreme Court in that year, where it's reversed. The BC Supreme Court decision is affirmed unanimously by the BC Court of Appeal, and then later it finds its way in 1992 to our apex court, the Supreme Court, which reverses that BCCA decision and reinstalls the member designates decision from 1987. Let's talk about the facts of the case. And so the facts concern Mr. Larry Renaud, who was hired by the respondent school board to be a custodian in their Spring Valley Elementary School, pictured just up here, which is in Kelowna, BC, over here. And so Mr. Renaud was to work a shift on Friday that would go from 3 p.m. until 11 p.m. That shift was entrenched in his collective agreement. Now there's a problem. Mr. Renaud is a Seventh-day Adventist, and Seventh-day Adventists hold as a religious practice that they're not to work on the Sabbath, which is from Friday sundown until Saturday at sundown. And so the board is required to accommodate Mr. Renaud. They make several recommendations. They recommend moving him schools, but the union isn't accepting of that. They recommend that he work a 4-day week, and that's not sufficient. And so finally, the most common sense recommendation is that he work from Sunday to Thursday, the same days but earlier in the week. And the union blocks that. So the board, when left with no other option, dismisses Mr. Renaud. Now, Mr. Renaud brings a complaint pursuant to the Human Rights Act of British Columbia. Now that act, then and now, held that neither an employer nor a union may discriminate against any person for a number of enumerated grounds, including their religion. Now, it's important to know, for your circumstances, that Section 7 and Section 9 of our Alberta Human Rights Act are analogous to that act. So the decision finds leave to the Supreme Court on two grounds. Firstly, is the schedule proposed or entrenched in the collective agreement a bona fide occupational requirement? And second, is the employer or the labor union under any duty to accommodate Mr. Renaud? Now, in answering that, the Supreme Court answers a number of questions along the way, or asks themselves a number of questions along the way. Now, the most prominent is, what is the scope and content of the duty to accommodate, and particularly in this case where it's a workplace governed by a collective agreement. That here is the rub. Now, is a trained union liable if they refuse to relax their provisions in the collective agreement to accommodate, or if they block the employer's attempts to accommodate? Must the employer, in that circumstance, act unilaterally? Must they willfully break the collective agreement, which, if I'm not mistaken, is an unfair labor practice? And what, if anything, is required of the complainant? To properly understand this decision and where it sits in human rights jurisprudence, it's important to understand the law at the time. So the member designate determines that the hours of work and the job allocation as provided in the agreement are not bona fide occupational requirements. The BC Supreme Court and that province's Court of Appeal find that the member misapplied the law as it was set out in Binder. Binder is written by, or the decision is written by Justice McIntyre. Justice McIntyre at paragraph 13 finds that only direct discrimination is prohibited. Adverse effect discrimination is permissible. If the requirement attaches to the occupation and not the individual, then any consequential discrimination is acceptable. Now, during that same period, a case called Simpson-Sears comes along. It says that an employer has a duty to accommodate short of undue hardship. Now, the question is, how short of undue hardship? So on the law at the time, Justice Dahm of the BC Supreme Court has no problem finding that the shift deals with the occupation and not Mr. Renaud specifically. Now, it's also worth noting that in the interim period between the Court of Appeal decision and Supreme Court decision, a case called Central Alberta Dairy Pool comes out, which provides that there's a duty to accommodate notwithstanding a bona fide occupational requirement. That was a wholesale change in the law between the decision of the Court of Appeal and the Supreme Court decision in this case in 1992. Now, Justice Sapinka delivers the decision of the court. Now, they start by breaking it into three sections, one for the employer, one for the union, and one for the complainant. Now, Sapinka finds that an employer must take reasonable measures short of undue hardship to accommodate the employee, including in the case of adverse effect discrimination. Now, he pulls law from a previous, that Central Alberta Dairy Pool case, where he finds that the undue hardship is a question of fact, but it must be more than minimal effort. And some of the factors in that can include costs, the disruption of the collective agreement, damage to morale, the interchangeability of the workforce, etc. Now, that list is not exhaustive. Now, the union claimed that the interference with the rights of other employees was a serious factor. In fact, this would be the thin edge of the wedge, prying the collective agreement away from the employees, they argued. Now, the court says that that is a factor, but it is not when those attitudes are discriminatory. For example, when the preservation of the collective agreement would mean Mr. Renaud was unable to work his job. Now, the court talks about the Human Rights Act and collective agreements, and it says that contracts must give way to the Human Rights Act, and the reason for that makes a lot of sense, and that's because the parties cannot contract out of a statute. And so what are they to do? Well, in the case of direct discrimination, the provision is invalid from the get-go because its specific purpose and effect is to discriminate. Now, in the case of adverse effect discrimination, the provision is valid in its general application, say to other employees, but the employee which is adversely affected must be accommodated. Now, the degree of departure from the agreement, the collective agreement, is relevant to considering the level of undue hardship. Where it would be a substantial interference with the employer's business, that would constitute undue hardship, finds the court. The court also deals with the union's duty to accommodate. Now, it starts by noting that the union is considered a person under the Act. And so they may attract liability in the same way that an employer attracts liability. And that's either, or in a similar way rather. They can do that, one, through participating in the formulation of or participating in a discriminatory practice. Now, participating in the formulation would mean being party to that collective agreement that discriminates. They may also discriminate by blocking an employer's attempt to accommodate the employee. Now, in the union's case, the primary consideration of undue hardship is the effect on other employees under that collective agreement. And so the factors are a little bit different. The court notes that we should be careful not to substitute one discrimination for another. And so in helping one employee, we can't prejudice all of the other employees, for example. Now, the complainant is required to do far less than the employer or the union. The complainant must assist in securing an appropriate accommodation, but they do not need to come up with the solution. They don't need to be the origin of that accommodation. That is a duty reserved for the employer or the union, and the union. And so all the complainant needs to do is to help facilitate the implementation of a reasonable proposal. What was the outcome of this case? Well, the Supreme Court restores the decision of the member designate and it finds that the proposed accommodation, working Sunday through Thursday, was reasonable. It said that the employer should have acted unilaterally and accepted the grievance, and that any grievance would be premised on a mistake of law, and that the union should have yielded to the accommodation. It said that Mr. Renaud acted properly. Now, that result was surprising, given the law had been there at the time. And so when presented with this fairly dramatic change in law, I've heard that Justice Sapinka said to counsel for the employer that, counsel, this was always the law, and our court is just expressing it. I'll leave it to you if you buy that. Now, this decision rather is impactful for a number of reasons. Mostly, it cements the duty to accommodate, and it clarifies that that duty applies in unionized environments and in respect to adverse effect discrimination. It clarified how far short of undue hardship the employer is expected to go, and the answer to that is to the level of undue hardship. Thanks for tuning in, friends. If you have any questions or comments, I'd love to see them in the discussion board. Thanks. Have a great day.